My name is Nomfunda Jele from the Law Society of South Africa. I'm joined by Buki Olawukaran and Gita Pala to briefly compare and discuss the key aspects of arbitration and litigation, and to identify the key features that you should consider where possible in deciding on a preferred dispute resolution mechanism. This discussion is not aimed at expressing a preference on either arbitration or litigation. The decision should be made based on the unique contextual considerations. We recommend that you consult a legal practitioner to advise you on a suitable dispute resolution mechanism. Buki sits on the Law Society's Court Practice Committee, and we'll be discussing the key aspects of litigation. Welcome, Buki.
Thank you so much, Ms. Jere. Thank you so much for the opportunity.
Okay, Buki, can you just explain to us what litigation is?
Okay, in a nutshell, litigation means two people are fighting, but in a proper sense, it actually means, approaching the court of law to settle an impasse or dispute that's probably ever risen between two parties. It does not only have to be two parties, it could be a party and a number of other parties or several parties with other parties, but there will be two sides and both sides will be wanting the court to resolve the dispute.
Okay, and thanks for that. And how is the presiding officer appointed?
Well, unlike the general belief, it's actually not the parties that appoint presiding officers. Presiding officers are appointed by the court. So they actually come part and parcel of the court process and obviously the litigation process. So the parties cannot do forum shopping of their preference for a judicial officer. It has to be the court that appoints. And the appointment of judicial officers in our country is actually regulated through the Constitution and through recommendation by the JSC for judges and recommendation through the Magistrates Commission for magistrates. That process, it's a very transparent process, and it seeks to obviously source out the best caliber of practitioners. And it's not only limited to practitioners, if you've noticed of late, that it also comes from academics, and obviously seeks to get the best caliber of candidates to preside in our courts for proper objective and fair, just and equitable decisions to be made.
That's very interesting. And how long does litigation usually take?
Litigation, the perception is that it takes a very long time, for litigation to be finalized. But the process is actually quite not, it's predictable because for court processes and litigation, there are procedural, time frames that parties must, abide by. So you can almost make a projection of how long it will take. But obviously, there are gymnastics that happens, through interlocutory and, unforeseen development within the processes that can obviously delay it. But I'm quite happy these days because of the introduction of the case flow management into most of our court system. The usual long delays, created by parties, is no longer common these days because the powers basically is taking now away from the parties to determine the timeframes. There is obviously the involvement of the judicial officer to ensure that the process is finalized expeditiously and to avoid prejudice of delay, which is usually common. So, except in instances of urgent application, the process is quite determinable through the rules that are set down for each court. Thank you.
All right, thanks for that. And in terms of costs, what costs are involved with litigation?
Costs is inevitable because the whole essence of litigating in court is the need to depend on practitioners who are obviously more experienced and expert in the field of the relevant dispute. So it is not expensive if you consider that the costs are also regulated within the procedure for each court. So, for instance, the court that is applicable in the magistrate's court is different for the one that is applicable in the High Court. However, when one considers costs as a potential litigant, you do not only consider the cost that is prescribed by tariff, you have to consider the cost that the practitioner would charge, and obviously that is contractual. So it is obviously based on each practitioner and their agreement between the parties. And obviously you have to also consider whether counsel will be required. The other factor that is important is very, very important, the projection that must be factored in the event of a litigant not succeeding with the claim. And the norm in our process is that the costs usually follow the results. And the discretion on cost is also, exclusively in the hands of the presiding officer. So before one litigates, all those factors have to be, considered. What will it cost me? And obviously, what will the other party require of me should I lose the case? So it's not easy to actually say it is expensive, but I guess any dispute takes a bit from you.
And then just finally, Buki, what are some of the common features of litigation?
Right. Litigation is interesting, and basically you're looking at how disputes get resolved. Now, we have specialist courts, we have different, fora, but in essence, you will have a situation where you have the pre-litigation processes. Obviously, that is where you consult an attorney to determine whether you have a claim in the first instance. And that obviously is still between the practitioner and the litigant, the would-be litigant. And once it is established that there is a potential, case that should be resolved by the court, then obviously the next stage takes place, and that is where the litigations we believe litigation starts before you issue summons. I'm using summons because sometimes it could be action. When it is action, it is summons that you issue. But when it is application, you obviously file the application, which will be an affidavit. The action results ultimately in trial where, viva voce evidence, and by viva voce evidence, I mean that people physically go to court and give evidence, But in the application process, whatever you have to say, the totality of the case is encapsulated in what you call a founding paper, and that you depose to it as the litigant. You don't have to be in court for that process. You trust, once the paper's filed, you trust that into your attorney's hand. So you have those preliminary issues, and once that is sorted out, then you go to the second stage where you inform the other party now that you have an issue that you will require the court to resolve. And that is when, in actual fact, you can start counting costs, so to say. And when you get indication from the other party, whether they intend to oppose or not oppose. And so there are different stages. There's the before, court process. There is at the beginning where papers are exchanged, which would be pleadings being exchanged. And once that is obviously sorted out, you go through the evaluation of evidence. It could be by way of arguments or, by way of discovery. And obviously, ultimately, everything results in judgments being given by the presiding officer. Yeah. That is usually not the end of the case. In some instances, an aggrieved party of the outcome of the process can obviously still take the matter up to an higher court based on our system of stare decisis rule, which says if you are in a lower court and you're not happy about the outcome, you can actually go to a higher court for appeal of the decision of that lower court.
All right, thank you so much, Buki. Yeah, thanks a lot.
I'm very grateful for the opportunity, and thank you very much.
Yugita Pala sits on the Law Society's Alternative Dispute Resolution Committee. Yugita will be discussing the key aspects of arbitration. Okay, Yugita, can you please explain to us what arbitration is?
Arbitration is a dispute resolution mechanism that is designed to dissipate conflict between parties. If we look at the Arbitration Act 42 of 1965 defines arbitration as a written agreement between parties involving the use of two or more arbitrators, as well as there can be two or more parties as well to the dispute, resulting in the arbitrators presiding over a dispute that is currently taking place or a dispute that could essentially happen in the near future. In practice, currently we are seeing that arbitration is taking on a more informal process. And this is really fantastic and welcoming, especially in the South African jurisdiction where we have always known litigation to be the forefront of resolving dispute. So I think this is a very fantastic welcome, especially in the area of alternate dispute resolution.
If I agree to arbitration, does it mean I cannot also go to court? And Yugita, who decides on the procedures regarding arbitration?
The procedure of arbitration is usually quite simple and flexible. We find that South Africa has welcomed arbitration as a fundamental forefront of alternate dispute resolution. So let's quickly talk about the procedure. The procedure, like I've mentioned, is simple, it's flexible, and it is usually contained in the written agreement between the parties. So the parties will decide on the procedure and the process that would happen in the arbitration proceeding, which is usually documented in that arbitration agreement. The arbitrator is the one that has a lot of power in the arbitration proceeding. And if we look at Section 14, subsection 2 of the Arbitration Act, this specifically empowers the arbitrator to call witnesses, to examine documents, to examine evidence put before it, and to make sure that all parties to the dispute are there to give evidence with regard to finalizing the dispute between the parties.
Thanks for that, Yugita. Can you please explain to us how the arbitrator is actually appointed?
The presiding officer of an arbitration agreement is usually decided upon very early in the arbitration. And this we find is that if parties have consented or reached consensus with regard to the arbitrator, this would be mentioned in the agreement between the parties. However, if parties cannot decide with regard to who the arbitrator would be, they can nominate or appoint an independent body or another person to make that decision for them. The arbitration agreement can also specify that a particular type of arbitrator would need to be utilized. For example, if the matter were to be dealing with, for example, an engineering contract, they would need to utilize an arbitrator that would have engineering law experience. So that actual arbitrator would need to be specified in the written agreement with regard to expertise and knowledge. And for example, parties could also decide that they would be more preferred to having an arbitrator with maybe 10 or 12 years of experience.
And how long does arbitration usually take?
The time frame of arbitration is one that is, I think, the greatest advantage. Arbitration is a mechanism that is supposed to be quick.
Thanks, Yugita. And Yugita, can you just tell us what costs are involved with arbitration?
The cost of arbitration is one that becomes slightly tricky. If the parties have decided that they are going to utilize a specific arbitrator, and that person's name has been cited in the arbitration agreement, they then can approach that arbitrator well in advance and have a recommendation or a suggestion from that arbitrator what they would actually charge as a day rate or an hourly rate to carry out that arbitration proceeding. But the usual costs involved in an arbitration proceeding would be the payment to the arbitrator, if parties have decided to use a venue, if there's catering involved, as well as if there are any expert witnesses that have been called in the matter to adduce evidence. All these parties would need to be paid. So at the outset of the arbitration agreement, it is very important that parties consider the costs involved in arbitration, and these costs would have to be borne by the parties.
And just finally, Rigita, what are some of the unique features of arbitration?
The fantastic thing about arbitration is that this is a voluntary mechanism. So parties cannot be forced to utilize mediation or arbitration in these circumstances. As we've seen in practice, that arbitration is totally voluntary. And this is actually opposite to litigation, where you could take a really irate client to court if he doesn't want to assist you in resolving a dispute out of court. So once again, with regard to that, arbitration is voluntary between the parties, and no party can be forced to enter into arbitration. The biggest advantage of utilizing alternate dispute resolution and a mechanism such as arbitration is the quick turnaround time. The duration of arbitration proceedings are usually quick, efficient, and effortless. And that is the reason why it has become a welcomed and it has become one of the more chosen areas of law with regard to dispute resolution. Arbitrators are trained in a way that allows them a lot of consciousness with regard to time management. So with regard to time management and how fast or how slow the parties need to go, this is an area or strength of an arbitrator. And this is why, again, this makes an area of law so commendable and so acceptable to members of the public.
Thank you so much. Thanks for your time. Bye.